Good evening, Crime Talk aficionados. This is Crime Talk. My name is Scott Reich. Thanks for joining us. It is Tuesday, June 21st, 2022. Lots of stuff going on out there in the world. Want to thank everyone for joining us. For those who maybe tuned in because this is the first time, or you're coming up on our YouTube or Facebook or TikTok channel, my name is Scott Reich. I'm a practicing criminal defense attorney, and we've been doing this channel for a couple of years now, and we try to bring you the legal news as it's breaking, particularly as it relates to criminal cases, but we venture out and discuss civil cases as well, but mostly, primarily, it's what we do is criminal defense work. Try to explain, what each side is talking about, what's the strategy behind it, and try to make some sense of what is going on in the world as it relates to crime. Because let's face it, most places, particularly on your evening news, you're not going to get any in-depth analysis or any explanation as to really what has taken place. So want to welcome everybody here who's doing this. Understand you all have lots of things that you could be doing, and the fact that you're here with us, we greatly appreciate it. Now, we did put out our daily video today. Hopefully you have watched that. If you have not, you will go check it out at some point this evening. But want to update something, because that's what we do. We try to be as accurate as possible. And in the story, the jury was still deliberating as it was in regards to the civil trial for Bill Cosby. As you may recall, he was being sued by a woman out in California, saying that she's now 64, but that back in 1975, she was a victim of a sexual abuse at the prime age of 16, and Bill Cosby was the one that did it. Late Friday afternoon, one of the jurors was going to be excused. The defense for Mr. Cosby said, "Judge, just excuse the juror, but we'll go with whatever the remaining jurors have come to the conclusion about, and that's it." And the judge said, "No, I'm going to honor my commitment to allow this juror to go on her trip that was been previously scheduled. So we'll just bring in that alternate juror, and that alternate juror will come in, but you have to start all over again." So it only took a day. The jury reached a verdict, and they said that, yes, Mr. Cosby was the individual that intentionally caused harmful sexual contact with Miss Huth, H-U-T-H. Judy Huth is her name, and she was awarded $500,000. I'm sure it probably costs that much for Bill Cosby to defend the case, if not more. Not really sure if there's appellate issues in that particular issue. Mr. Cosby should just be like, Bill Cosby should just be like, where would you like the check made out to, so that the matter would be done, complete, and over with. So wanted to give you that breaking news. Also, there's big news going on up at the Supreme Court. Obviously, their term is coming due. It's going to be over quite soon. And obviously, many people are waiting for the whole case regarding whether Roe v. Wade will be struck down. Today, the court strikes down a law in the state of Maine banning the use of public funds at religious schools, which is a big issue. If anyone's interested in that issue, that goes directly to the legal issues regarding vouchers and school choice. And basically, the Supreme Court, the 6-3 ruling, said that's discriminatory if you're going to offer these funds, but you say that it can go to any private school, just don't let it be a religious school. Supreme Court struck that down. There was a case, divided Supreme Court rejects death row prisoners' attempt to gather neurological evidence. This is issue as it relates a lot to the criminal defense, particularly in death row cases. Um, Supreme Court dealt another blow to prisoners challenging their state court convictions and sentencing in federal court. That's what refers to as a habeas proceeding. And a 5-4 decision in Shoup v. Twyford, Twyford, the justice limited the ability of federal courts to use All Writs Act to order states to transport prisoners, even when such transports could help prisoners investigate whether their convictions are unconstitutional. This is, in this case, a federal district court relied on the All Writs Act to order an Ohio prisoner warden, Tim Shoup, to transport state death row prisoner Raymond Twyford to a medical facility for neuroimaging. Twyford sought the neurological imaging to try to show his brain damage from his childhood gunshot wound had been impeding his cognitive functions and behavior. He wanted to use that information in his federal habeas proceedings and challenge his state court conviction, and it relates to the death sentence. The warden appealed the transport order, and the United States Court of Appeals for the Sixth Circuit agreed with the district court. Once again, another opinion written by Justice John Roberts, the Supreme Court reversed. The district court, Roberts explained, was wrong to grant Twyford's request to transport order because Twyford's never demonstrated that the evidence he sought would be admissible in his habeas proceedings. The neuroimaging results would not, in fact, be admissible because of stringent limits in the federal habeas statute on presenting new evidence. So that shut that down for federal prisoners as well. Now, then we have other issues out there. Amber Heard, did that, when you have a set off, you have $8 million that you could potentially have to pay to your ex-husband, Johnny Depp. Is that going to make you frugal all of a sudden? A lot of people are upset, or I guess think that she's just putting on a show as it relates to her going out to TJ Maxx and going shopping there in, I think it was New Jersey, wasn't it? Long Island, where she was out there going shopping. It's always interesting. Let me know if you think that's just a ploy. I think she's doing this in reverse order. She should have focused her time and energy on the court proceeding where she was being sued for defamation and tried to look like a nice, happy person versus coming across as a horrible human being, as she did, and now trying to come across as everyday Joe. Like, what universe is she living in? The case is over, and that is it. There's really nothing for her to do other than take it up on appeal, and maybe the court will say, yes, since Mr. Depp is a public figure, you have this free speech right to say what you want, and it wasn't actual malice, because she believes it to be true, but the jury has found that it not be true. And I'm a little surprised Amber Heard perhaps did not, could wind up getting sued again simply for the fact that she has really doubled down on the statements of what she said was true and everything that she said in that Washington Post op-ed, even though she didn't write it. Somebody from the ACLU wrote it, but by God, it was true. Doubling down for sure. So yeah. And as somebody says here in the comments, Chile, it looks like she called TMZ again, because obviously that was one of the allegations when she was going to seek a protection order against Johnny Depp, that she obviously, or that she maybe possibly called TMZ so that they could get a picture of her at the courthouse. So yeah, what can you say about Amber Heard? I mean, like I've said this before, I'd never heard of her really at all until this case came about. Couldn't have told you what she acted in, who she was married to at the one point, Johnny Depp, what she'd ever done. No idea. Frankly, even to this day, still don't care what I would see. It was funny. The lovely Miss Kristen and I were home one Saturday afternoon, and Aquaman came on. And out of curiosity, the lovely Miss Kristen was like, "Oh, I want to see if she can act." It became rather clear that she could not act very well. She could have the producers, the directors in that case, probably could have grabbed somebody off the street and competed with um, um, with Amber Heard. So yeah, and then obviously we still have a lot of the criminal cases pending. It just seems like they drag on forever. We have the Lori Vallow, Chad Daybell matters. I mean, they just drag on. I mean, 3 years. I mean, I get it. It's a case where we have had competency issues for 10 months. Okay. Uh, it's a death penalty case, but the prosecutors piecemealed this case together. And the prosecutors in this particular case, the Lori Vallow, Chad Daybell case, I was really kind of rooting for them. I thought they were doing a pretty good job. But ever since the indictment has come down regarding the deaths for JJ and Tylee, as well as Tammy Daybell, it just baffles me that they come across with this situation where they just don't seem like they are ever going to be ready to go to trial. It's been no secret that Chad Daybell wants a separate trial from Lori Vallow. That still may happen once the court actually holds motions hearings in the case. And I would imagine one of the greatest reasons for a severance of defendants that are now technically joined in the same indictment is at some point, Mr. Pryor, the attorney for Chad Daybell, is finally going to say, we have inconsistent theories of defenses here. And that normally in and of itself should warrant a separate trial. So all of the legal gymnastics that the state has gone through to keep these cases together, and I just don't get it. Okay, I take that back. I understand why the prosecutor doesn't want to do the case twice. It's going to take 6 weeks to try this case. So what? You are going to be able to figure out all the flaws in your cases by the time you get to the second one. Okay. Chances are, and statistically pretty good, that the prosecution is going to prevail in this case. Now, understand they have a heavy burden to prove. That heavy burden is proof beyond a reasonable doubt, which is the legal standard in all criminal cases. And if the prosecution fails to do that, then the defendant should go free. But they just keep acting like they don't want to go to trial. I'm telling you, any prosecutor, the one that's going to win, that knows he has a winning case, is going to say, I don't care when you tell me to be here, Judge. I'll have my witnesses. I will move mountains to get all the witnesses that I need here on this particular date. And we're ready to go. We accept this heavy burden that has been put upon us by the court systems and our judicial system, and we are prepared to meet that burden. It is a heavy burden, and we acknowledge it, and we accept that burden. But they just keep acting like, don't make us do this. It's so hard, and to do it twice would be so expensive. Justice is expensive, ladies and gentlemen. Justice is expensive, and they just need to go try the case, whether it be once or twice, or even 3 times if there's a mistrial or something along those lines. Go try the case. What is the defense going to be, right? Idaho doesn't have a not guilty by reason of insanity defense. And we've talked about that before. When somebody is found not guilty by reason of insanity, when they have that defense, it's an affirmative defense. It says, yeah, I did it, but I couldn't form the requisite mental intent to do so. And therefore, because I have this mental disease or defect, and therefore I should be found guilty by reason of insanity. It doesn't excuse you. You don't go home. You go to the mental health hospital. Look at John Hinckley Jr., the guy that was basically found not guilty by reason of insanity for shooting President Reagan, Press Secretary Brady, and a Secret Service agent as well. 45 years in the mental institution, and now he is out. But it took that long. I don't think that is necessarily a big win for the defense, so to speak, when you've been locked up in the mental health institution for 45 years. But since Idaho doesn't have that and say, oh, we're going to ship them off, then everything goes to whether you can form the requisite mental intent. Did you know? Were you aware of what you're doing? Remember, in every criminal case, the prosecution has to prove that it was the defendant and that they acted knowingly. Okay. They knew what they were doing, aware of their consequences. But if they are so mentally diseased or defective, how do they know what they're doing, right? Lori Vallow is alleged to have been running around saying the zombies, the great apocalypse was coming for them. And, if you actually truly held those beliefs, and obviously she must have truly held these beliefs to the point where she actually convinced the medical doctors that she wasn't malingering the entire 10 months that she was down at the state hospital, that's pretty persuasive evidence that during the commission of these offenses, you may have had an issue with, a mental disease or defect, right? It's pretty straightforward. So yes, it's going to be interesting to see how that plays out. Now, Chad Daybell, on the other hand, what has he got going for him? I think what he is going to do is simply say, I had no idea what was going on. I got completely duped by this woman. And the guilty parties are Lori Vallow, who may or may not be suffering from a mental disease or defect, but her brother, Alex Cox, who more than likely is the one who actually committed the murders, did the deeds. Well, he's now dead. What is the best defense, ladies and gentlemen, in any kind of a homicide case? The prosecution has to prove identity. They have to show that it was the defendant, not someone that looked like him, not someone using their identity, but it was in fact the defendant who committed the crime. Now, it gets a little more difficult when you have a conspiracy, but who's going to come and testify to this conspiracy? Now, we don't have all of the discovery, obviously, that hasn't been turned over, made publicly available just yet. It will be after the trial, it should be. But for something to be admissible, right? We've talked about this. You have to have legal and competent evidence to be admitted into court. Yes, just about everything that the defendant says comes in as an admission or statement against a party opponent, right? That's why we keep saying anything you say can and will be used against you, bottom line. And it's hearsay evidence, it doesn't come in, it's inadmissible when somebody else testifies to what somebody else said on the witness stand, other than the defendant. Well, then you have this issue about the phones, right? We have heard some evidence that, I wouldn't say evidence, we have heard reports that the prosecution has evidence regarding text messages between all of the parties, okay? Now, one of the things you have to really be careful of when you say, well, we have text messages, okay? Now, this gets a little into the weeds here, okay? But how do you get something into evidence at trial? And it gets more complicated the more layers of digital evidence that supposedly are there, okay? Normally, Let's say I want to get into evidence this piece of paper, this document. Do you think in court you just say, we would like to admit defense exhibit A into evidence? No. You have to have a witness, and that witness is going to have to authenticate that document. So the attorney would go up to the witness stand and say, witness, will you take a look at this document? Do you recognize this document? Why, yes, I do. Well, what is that document? Well, I wrote that document. Well, how do you know that you wrote it? Well, I recall writing it up. It's on my letterhead. And yep, look here. If you look on page 2, it's even signed by me. So I wrote this letter. And they would maybe ask, do you, or ask some relevance questions. Is this relevant to the dispute here at issue? Yes, it is. Ask for the admission. Well, it's been authenticated. I wrote it, assuming there are not statements in there from other people in the document, because you can have hearsay within hearsay. That's really getting deep into the woods. But if the letter writer can say, I wrote it, then he's authenticated the document, and then it can be admitted into evidence. So think about that. You say, let's say you have a phone, okay? You have a phone, and I can tell you I had to get a new phone because I lost a phone. And let me just tell you, this phone, worst thing ever. I'm trying to get used to it, but not working. But let's say somebody says, let's take a look at this phone, and they go get a court order. And to get into that phone, they get a court order that says, Judge, we believe there's going to be something of evidentiary value. And we think that we're entitled to a phone. Now, unless the person consents to the entire contents of the phone, the police can only go in and get what they've been authorized to look for. They say, Judge, we're looking for text messages between, the defendant and so, another co-defendant between his particular dates. Guess what? That's all they get to go look for. They can't just dump your phone. Okay. And if you go outside of that, where you draft the warrant incorrectly, we had a lot of these cases about 2 years ago. It seems like they fixed the problem, but we were getting all these phone searches. They're like, yeah, we want to search your phone because we think there's evidentiary value. We as police officers believe and know that people have all their identifying information, important information on their phone, and we want to look at it. And so they would dump the entire phone. Well, that's a general warrant prohibited under the Fourth Amendment, ladies and gentlemen. Warrants have to be specific. They have to be narrowly tailored to know what you're looking for. You can't just go in. You basically have to know what you're looking for before you get there. You can't just say, we're going to go rummage around and look for it. Okay. So let's say the prosecutor says, hey, we believe this is the phone associated with the defendant, and we would like to take a look at the phone, and we're going to limit it in scope to this particular time, and it's a valid search. So they dump the evidence, and they got these emails back and forth. Like, oh, this is great. This is great stuff. The defendants are confessing all over themselves. They're making statements in further of the conspiracy. It's going to be grand at trial. The prosecution's going to have fireworks going. The American flag is going to be coming down, and they're going to be, standing at attention singing, God Bless America, Star Spangled Banner, right? And then the prosecution is going to say, witness, did you take a look at this cell phone records, and what is it? We believe that statement of the defendant. Objection, hearsay, lack of foundation. Hate to be the one to throw a stick into the wheel there of the bike as things are rolling down the street, but you still have to be able to show, just because it's on, let's say it's on this phone, and this is the defendant's phone. You still have to put the defendant at the keyboard, right? Just like, think about it. if you have computer evidence, somebody's writing or going to a inappropriate website, just because that IP information is on the computer does not necessarily mean that the person is the one that they charged is the one that went to that inappropriate website. So although the computer says they went there, the prosecution still has to put the individual behind the keyboard. Okay? Same thing with the phone. Well, who all knows the password to your phone? Is it even locked? Can somebody get to it? Maybe I leave it open and I walk by when I run to get a drink from the kitchen here at the office, and somebody typed something on there, and I was like, oh my gosh, I can't believe, how did I get there? Somebody else typed it. Okay. So even though the prosecution may have a ton of information from phones, they have to get it into evidence. Okay. Now, we've talked about this before. These phones are terrifying and wonderful in the same regard. One, about the information they have and the convenience it brings to us, but the amount of information that it saves, even without your knowledge necessarily taking place, is scary as heck. Because what do the police do? They say, well, we want to see where this phone was. Like, for example, with JJ and Ty Lee, they were up in near the Yellowstone area there in Idaho, Wyoming border, when they supposedly went missing. That was the last photo taken. So they get the computer, the phone information. Who is the subscriber information for? Oh, we believe this to be Lori Vallow's phone, or Chad DeBell's, or Alex Cox, or, who knows, maybe they got the family plan and they got 5 phones. So you have to be able to show who did it. But there's still information that will potentially be available based upon the phone through these information providers. And this is the scary part. Okay. Google, Apple, they're constantly following you. They can tell you where you're going, where you've been. They can literally predict where you're probably going to go. I mean, I don't know about you, but my car, I get in my car at night and it makes a suggestion where I should be driving to next. Little freaky, little weird, right? Heck, we saw this presentation on like artificial intelligence stuff where it literally thinks like, it's just crazy scary, right? Anyway, we digress. Anyway, so that information is there. They can get that and say, well, you know what? This phone was registered to so-and-so, and we believe it was involved in this case. And we're going to be able to track it around, and we're going to be able to look at its location due to the cell phone towers activity. Heck, when you walk down the street and your phone tries to connect to all the little Wi-Fi signals that everybody has for their guests, it's keeping track that it tried to log on to that information, and they can literally follow you, track you around everywhere where you go. It's absolutely crazy, but you still have to get somebody in. So how do you get that evidence in at trial? I mean, it's a boring business record, right? But that's it. It is a business record. And one of the exceptions to the hearsay rules is that it's a business record. It means that it's a record maintained in the ordinary course of business that most people presume to be accurate, right? We've all known somebody that has a box full of receipts and they're saving it for tax. That's their business record filing system. They're keeping it for the records, maintained in the due course of business, so to speak. But a better example of a business record is when you think about when you go to your bank. You're like, you know what? I need to get a statement from 8 months ago. I just can't seem to find my copy that we had. I need to get it. And you go there and you presuming that the records are in fact accurate because they have a duty or some sort of a good requirement to make sure that those business records are accurate. And so there's some reliability that goes with business records. They keep track of every transaction that comes in. They keep track of all the debits and credits throughout the process. If you're overdrawn, anything along those lines, they have a reason to do that and to maintain that accuracy. But if I get sued and I say, you know what, I want to make a great chart to show all the different receipts that I have for these documents. And yes, it may be made up of other documents that I maybe keep in a business record or not. But if it is made in anticipation of litigation, it's not a business record. A business record is something that's going to be maintained by the business all the time, regardless of what is going on in the world. Hopefully that makes sense. Okay. So going to trial, going back to Lori Vallow, Chad Daybell, whether it's one document, whether it is a lot of phone records, you have to have somebody to come in and authenticate and identify those phone records as being their records, that they're maintained for a certain period of time, and that they're accurate. Then you have to bring in somebody to actually analyze it. So let's say they get all the phone records of showing everywhere where that phone was based upon the cell phone tower triangulation. You get the tower, you get the lat, lodge, and the little longitudinal locations that you need. You plot that, and you can literally start plotting where the phone was. Okay. But then you need somebody else to plot that as well, an analyst of some type, to say, this is what we did and this is what we found. And no, guess what? We found that there was a phone on the Daybell Ranch, and coincidentally, it belonged to Alex Cox, and he was moving around the farm or the house within, say, 3 feet accuracy. And we know at this time he would probably be right about here, mark the dot. And they'd say, oh, and by the way, we just happened to find the remains of JJ and Tylee right about here, mark the spot. Okay. So it's not a simple process. And the government would have to do that for each and every phone record, any sort of expert witness. This is going to be a very heavy witness as it relates to foundation, which is getting something into evidence, authenticating it, being able to properly identify it, and then determining if it is in fact relevant. Now, let me tell you a dirty little secret. Prosecutors hate this part of their job. They hate it because it's boring to their case. They'd like to be able to just walk up, Your Honor, we would like to admit prosecution exhibits 1 through 6, which is a series of binders with all of this data. We've come to a stipulation with the defense, and we move to make this admissible, and we will publish at the appropriate time to the jury. Prosecutors love that. Okay. But let me just tell you, from a defense attorney perspective, game on, right? Particularly in a case like Lori Vallow, Chad Daybell, you're trying to kill my client. Game on. Nothing personal, but the only thing I'm going to wave over here is the American flag. Dun, 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 dun. Just a little bit of thing. The prosecution comes out with lights and the flag coming down. Well, the defense just has the little flag. Dun, 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 'cause that's all, we can afford. And we're waving that flag. And we're like, oh, boy, I would really hate to make you prove to get all those records in, but go for it. Okay. And sometimes they can't do it. Sometimes the prosecution brings the wrong person. They don't bring the right person that can properly authenticate it. And now most of the phone records people say and I kid you not, like T-Mobile, Verizon, AT&T, they have people that is their only job to fly around the country and authenticate phone records to come into evidence. I swear to God. They get up and say, I'm familiar with how the records are kept, stored, retrieved, compiled, and presented here today in court. They can tell you what each column represents when it's just a bunch of numbers and how to interpret that and blah, 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 blah. That's their job. They're literally, that's their job. They get an assignment. Tomorrow we need to be in Denver. And when you get done with Denver, then you're going to fly to Salt Lake City. When you're done with Salt Lake City, we're going to fly to New York to testify in this particular case. That's all they do. Because if a defense guy goes, yeah, prove it. Get him in. Can't get him in, huh? So it's always fun and interesting when that takes place. And the prosecutions should just understand that they're going to have to do that on their own to get that in. So we'll see if the prosecution in the Lori Vallow, Chad Daybell case is going to do it. And what I mean by it is if they're going to be able to get a conviction. I like Mr. Wood. He seemed ready to go. Like, let's do it. I'm ready to go now. If you want to do it, trial that is. And now it just seems like, since the new prosecutor's taken over, it just seems very low key, very chill. We don't need to go. The defense is going to need some more time. They're going to need more time to get prepared. Why is the prosecutor doing that? I mean, it made it sound like they were the defense. Judge, we need more time to confer. It's not going to be that inconvenient. Let's set the trial date out until January of 2023, which don't even get me started on the whole speedy trial ruling. Okay. But I can tell you, I think that it is wrong. We'll see. It'll probably be years at the way things move in the Idaho court system. This could be at least another decade. Okay. It's just taking forever. And I had a case that would start out as a death penalty case. And the first 6 months we did mitigation, but we were still at trial from the time I think I first received that case to the time that we were going to trial was a year and a half. Bottom line. So yeah, it just seems like we're wasting a whole lot of time. I don't understand. And for the families, they want justice. I understand the defense needs to be able to prepare. I get that. I understand that. But the state has just as much right to a speedy trial, the public does, as the defendant. Okay, let's go to some questions here real quick. Main Street Flamingo. Scott needs to check out the case that broke this week in Louisiana, where a mother lost custody of her child to her rapist. She has also been ordered to pay him child support. Main Street Flamingo. We actually covered that case last week and today. Yesterday. What's today? Tuesday. Yeah. So if you watched the video yesterday and today, we talked about that case. Things aren't exactly the way mom is making them out to be. Okay. As a general rule, courts usually don't like to take kids away from parents. You got to work pretty hard at that. And in this particular situation, although the laws there in Louisiana at the time say that anyone engaging in carnal knowledge with someone under the age of 16, that they could, it's basically a statutory rape. Well, it turns out the gentleman, I don't remember his name off the top of my head, but he was apparently talked to the police and said, I did nothing wrong because she lied to me and had a fake ID, said that she was much older. And also the woman waited 18 years, 16 years to come forward with that. Just coincidentally, when it just happens to be where the father, who didn't even know he was the father, I think until 2011 or something to that effect, apparently wanted to be involved. He was concerned about the child in the home of mom, because apparently she had many a boyfriend coming by, and he thought it was not a great influence on her. Well, apparently so did the court. So that's one of those cases where, okay, this is what the law says, but apparently someone exercised a little prosecutorial discretion. And depending on when she first made the claim, more than likely, and I'm not even going to even claim to profess the laws of Louisiana. I have no idea. But my guess is they more than likely have run. But if I'm wrong, that's it. But a prosecutor also has discretion. Okay. Yes, there are laws that says if you have, engage in carnal knowledge with someone under the age of 16, that's a crime. But at 16, you also have a defense that they held themselves out is to be over 18. And if they do that, you get a reasonable belief, if someone's like, well, yeah, the girl was 12, but I thought she was 21 and she looks like a little girl, no one's going to believe that defense. But if she's 16, looks like she's going on 28, they may say, that's reasonable. Like, why is she out at the bar at 2 a.m. meeting with guys? Like, makes you think something's not right there. So I'll admit I was a little concerned when I first read the story, but as more information came out, I was like, things are not always exactly the way they appear to be. And there's usually two sides to the story. Roberta, anyone that kills, aren't they considered do you have some sort of mental issues? And where do you draw the line on that? Kind of going back to the NGRI. No, I mean, I get what you're saying, Roberta, but if somebody, I mean, I've met some very, very bad people over my years of practice that, would have no qualms whatsoever about doing serious bodily injury or causing death for no apparent reason. They would probably do it for the mere pleasure. Okay. There's bad people out there. Are they wired right? I don't know. Maybe they're wired completely wrong. Are they mental? I don't know. Maybe they just don't have a conscience. But that's a lot different from somebody that has a mental disease or defect that can't really appreciate reality, right? You have to be able to understand what's going on. Okay. If I was to get up and walk over, I'm not going to pick Julie because that would be, if I were to walk over and punch Frank in the arm, right? And Frank's like, what are you doing, Scott? I'm the hardest working man in show business. You wouldn't be anywhere without me, you loser. Why'd you punch me? That hurt. I'm calling the police. They would come to me and they'd say, Scott's of the basically sound mind and body. And he knew what he was doing. Sure, I walked over there to punch Frank, but maybe I didn't mean to hit him that hard. And I thought maybe I was just kind of joking around with him, but I'm sorry that it caused him pain. And so bottom line is that I knew what I was doing. I was aware of my conduct, practically certain to cause the result, that I was moving my arm back and I hit Frank. Maybe it wasn't the desired result that I intended, but the act of doing it is what they have to prove, not that you intended to cause the act, under some circumstances, like after deliberation, like you meant to harm somebody and you thought about it and you thought, wow, this is really the way I'm going to do it. And it's going to be slow and it may be painful, but it's going to be so much fun to watch, right? That's after deliberation. And so, going back to the example, I knew what I was doing. I was aware of my conduct. I knew that I wanted to hit Frank, but I didn't mean to harm him that bad. Maybe Frank's really fragile. Instead of a bruise, I actually broke his arm. And that would be bad, right? I didn't mean to do it, but that's mitigation. I like Frank. I wouldn't be anywhere without him. And the fact that I broke his arm, it wasn't intended, but I meant to hit him. That's the only thing that matters there. So hopefully that example helps make sense what the prosecution has to actually show. Heather, I bet Frank could take you. Probably. Let's see here. Look, a couple more questions here. Okay, that's something about I'm not really talking about. See, tomorrow. I remember when men used to punch kids in the arm to say a friendly hello. How you doing? Put her there. Right? Um, yeah, that's what they used to do. Maybe that was just my way of greeting Frank. I didn't know that he wanted to, call the police, but that's all they have to prove. I knew what I was doing as well as my conduct. But let's say, for example, I have a mental disease. I'm schizophrenic. And I didn't think that I was hitting Frank. I was hitting the three-legged dinosaur that's been following me and that was going to eat me. Okay. I didn't really, Frank was not a three-headed dinosaur, right? He was Frank. But because of my mental disease or defect, probably some sort of schizophrenia, I thought that they were going to attack me. I didn't really appreciate, know what was going on. Okay. Because I have a mental disease or defect. But let's say, for example, somebody slips me LSD and I start tripping, walking around, and I think Frank is the three-headed man and the three-headed man is going to attack me. Does that mean I do not understand and appreciate what's going on? No, you can't use drugs and alcohol to say that I was not basically aware of my circumstances. If that were the case, we'd have no crime because most of the crime is committed when people are high or on drugs. So, drunk or on drugs. So, yeah, hopefully those three examples kind of explain what the prosecution has to prove. Okay. Let's see here. Mama Pink, lawyer, guns, and monies. That's right. Rebecca said, Scott, you should have checked out the Johnny Cashman's death in Virginia. Seems like police screwed up bad. Chilling surveillance footage. There's good video summary by Aaron, whomever. Okay. I appreciate it. If you guys want to send us tips or whatever about stories you think we should cover, send them to us. Bottom line, we'll try to take a look at it. I mean, there's only, how many cases are going on out there in the world. And if I had, 10 Franks and Julies, I could probably do it, but we've got Frank and Julie and me. And so sometimes it's kind of hard to keep what's going on here. Oh, here, look, somebody has a thing. Mama Pink, that actually happened to me, sort of. Broke her teeth, not on purpose, but she told me to hit her over and over, so I did. Fired my phone computer too, laugh aloud, right in front of the judge, too. Tiffany, if there are other DNAs that come other than the victim and the suspect, are they supposed to be tested to prove who they are? Good question. DNA, always good stuff. I really enjoy DNA stuff. Okay. So when something is tested, let's say for simple purposes, somebody was accused of a sexual assault. And the victim said, oh, all these things happened to me. The sane nurse, which is a sex assault nurse examiner, is going to ask you, okay, where did he touch you? Did he kiss you, lick you, do anything? So, well, yeah, he kissed my neck. So maybe they'll do the fancy they'll get out the little Q-tip and they'll rub it on the neck there and they'll put it in there and they test it. And they send it off to the lab. And, after they pull off the little sample from there and they put it in the lab and do everything. And let's say that DNA comes back as a mixture. You're going to have your major contributor and maybe a minor or multiple minor contributors as well. At that point, they do their calculations, say, okay, this is a major contributor, but it's the victim. So that makes complete sense. The other minor contributor is the suspect. And we know that because we obtained a court order under Rule 41.1, and we obtained his DNA sample pursuant to court order. And we tested his. We're certain it was his because we sent our investigator over. We took the swab. We put it in there. We tested it. All the chain of custody is good. But who is that mystery DNA evidence? Who knows? Sometimes they'd go back to the victim and say, was anybody else kissing your neck that night? And the victim would say, well, no, I don't think so. Or maybe my boyfriend, he kissed me earlier in the day or whatever. So maybe they said, well, let's get a known DNA sample from your boyfriend, and we can compare that to see if his little charts are, his little DNA samples match. And if that takes place, and the match is okay, that's him. They've eliminated who the other DNA is. But let's say they said, lady's like, no, no one was touched my neck. We have a mysterious DNA sample. Where did it come from? The only real way, and if it's a mixture, it may not be a good, solid mixture with enough for them to make a match for it. They would plug it into, they being the police, may plug it into the results, that is, into the CODIS system, CODIS. It's all capital, and I don't remember what the acronym stands for. But they would put in the CODIS, and they would see if maybe they get a match. And if maybe it matches somebody that's already in the system. How do they get people in the system? Well, it's people that they've collected their DNA databases from when they get arrested. They've been collecting these when they go to the Department of Corrections, when they get arrested on felony cases. And so they have it to compare to it. You've heard about that when people get a DNA case. A CODIS hit means they matched with an unknown DNA. So that's how they would do it. So a trial, obviously, the more mixtures, the better, right? I've had sexual assault cases where there's been a mixture of like 6 people when they do the various swabs from various locations. And you're like, why are you charging my guy? There were 6 other people there, apparently, right? And sometimes that's good, sometimes it's bad, and somebody's just like, oh yeah, maybe it was a little more consensual than she maybe led on to the detectives. You just never know. Or, oh my God, they were all holding her down, and it could just be terrible. Terrible. We don't want to get there. So anyway, we don't want to get demonetized, right? So good question, Tiffany. Let's go on here. So let me tell you, we have a couple of changes coming up here. Couple of changes. To our surprise, I know, Julie is leaving us. I know. She wants to give all this up on her Tuesday nights because she wants to go be a pilot. Now, I get it. I'm a pilot. I'd love to go be a pilot. Well, guess what? She's going to go be a pilot, go train and be a pilot, take a little break and be a pilot. I think we'll need her for reference purposes, but she's preparing the book so that we all know what Julie does and how to do it here in the future. So if nobody in the Denver area, it's got to be local. It's got to be in-house. We don't do work from home. Okay. We don't do that. Let us know, what? I know people are like, what? Jenlo, what? I know. I was just as surprised. But what am I supposed to do? Say no? Don't go be a pilot. Don't go make a great living. See the world. No, stay here with me. Right. But that's the way that goes. But don't worry. Frank, the hardest working man in show business, is going to remain with us because I'd be nothing without him and nothing with Julie. So although Julie has a couple more days, this is our last live with her. So, oh, you'll join the lives. All right. Well, so our thanks goes as our thanks goes out to her for that. So we thank her. And so whoever takes her place is going to have some big shoes to fill as well. But we think we're going to do that. The other thing is, I told you I wanted to build a media empire. I know Julie's going to miss out on it. I don't know what to say. Media empire. Yeah. So when when Frank and I are rich and flying around, hiring her to fly us around in our jets, we'll hire her to come do that. So we're also starting another channel. There may be another one too, but the one that we started is called CrimeTalk TV. Now, if you're a Patreon, you're going to get a sneak peek at this tonight. And you may ask, why would I want to go to TV? What are you guys going to have on there? And I'm telling you, I don't know about you guys, but when I grew up, I remember going home on afternoon reruns and watching like Perry Mason. Okay. Some of those old lawyer detective shows were the best. Now, unfortunately, I can't get licensing for Perry Mason, but some others we were able to get our hold of those. So tonight we're going to get a preview for all our Patreon members. So if you're not a Patreon, now would be a good time. And we're going to preview one of these old shows. We're going to watch it all together. It's going to be a blast. You can comment. You'll still be able to call in. It's going to be a hoot. And, we'll go from there. We're going to go do that real soon. Columbo, there's so many of them, but I don't think I can get a license for that as well. Like I said, there's some of them out there that are, you can license just about anything, but it costs money. Okay. We had an experience today. We're like, okay, I want to do this and this would be great for this tool. And they're like, okay, great. We can do it for you. But the first year is only like $45,000. But the good news is it's only $25,000 a year after that. And I was like, excuse me, call me back in a year. Maybe the prices have gone down just a little bit. So many things are expensive like that. Yes. So that's what we're going to do. So hopefully, if you haven't already become a Patreon, now would be the time. And yes, it probably shows my age, but these shows were old before I was even born. But man, they're so good and nothing changes. It's the same stuff went on, back in the days, so to speak, that goes on today. Nothing's new. It's all just repackaged with new technology. So, all right. Hope you enjoyed our live program. Come watch us on our Patreon show. It's going to be a hoot. Remember, you can call in. Come and tell Julie, bye. We'll miss you on her last live, but we'll see if we can hopefully find somebody to replace her. Where she's gallivanting all over the world, traveling, becoming a professional pilot. So, I mean, what can I can't blame her for that. Like, geez, but it'll all work out. I know it will. All right. Thank you all for watching. Come join us on the Patreon page. It's going to be great. I think you're going to like it. Hey, if not, we tried. Come join us. See you on Patreon in a couple of minutes. We'll see you next time on Crime Talk.